Our second and final case of the morning is Worrell versus Florida Farm Bureau General Insurance Company, case number 2025-0267. On behalf of the appellant,
Always the guy that has to adjust the equipment. Try to go back for you when I'm done.
how much time
Five minutes.
for rebuttal?
Great, thank you.
Thank you. Have you announced your appearance for the record? That would be appreciated.
May it please the court, my name is Chad Barr, and I have the privilege of representing the appellant in this case. I've done almost 100 appeals, oral arguments in my career, and this is probably the first time I've showed up with not a lot to say, but anticipating a lot of questions, because this is an issue that's been decided by 2 other districts. And depending on how this court decides this case, it could be something that the Supreme Court has to decide. So,
And thank you for that, Mr. Barr. Where in the text? A lot of talk of
I knew it was coming.
a lot of talk about the text from Judge McIver and the previous OA, but where in the text of section 624-155 does it say that an insurance company waives its defense to a notice, a CRN notice, when it is not alleged with specificity?
That language doesn't appear in the statute, just like it doesn't appear in the Med-Mal statute. It doesn't appear in the property insurance statute. It doesn't appear in the sovereign immunity statutes. It's not there. The question is, what does an insurance company do? Are they making conduct? Are they undertaking conduct that gives the impression that they're relinquishing the right to something? That is the question. So we're looking at conduct.
I forgive you if you don't know the answer to this question, but does the concept of common law waiver appear in any statute?
No.
That creates a cause of action?
Not that I'm aware of.
Okay.
Not that I'm aware of. So,
Andy, you mentioned the Med-Mal statute. I'm well familiar with that. That was my life for a long time as a lawyer. And you're correct. There is no mention of waiver in the statutory text, but it is recognized that if there's an assumption of a duty that maybe didn't exist by some healthcare provider, and or a failure to elucidate fully all the potential foibles, problems with a pre-suit notice, it could be waived. And I fully understand that. But given all that, Mr. Barr, a lot has been made of the Ingersoll case, and that seems to be the seedbed of a lot of these other cases. Ingersoll seems to me, this judge, to be a case of waiver in the pleadings as opposed to a waiver based on a failure to respond to the CRN. So explain to me, if it's part of your argument, why Ingersoll would bind us here.
my answer is very simple, that the Evergreen Court looked to Ingersoll for the very, very small, very tight proposition that the statutory requirement can be waived. I think that's the extent of Ingersoll's place in this case. I think we spend 10 pages of an answer brief having to explain away Ingersoll. That kind of demonstrates that we're losing the point there. The point literally from the 4th DCA's perspective is that the right to receive a compliant 624.155 pre-suit notice can be waived. And that's, I believe, is the extent of Ingersoll's purpose.
And this judge, and I can't speak for my other 2 fine colleagues, I fully agree. It absolutely can be waived. It's just whether it was is the question. And help us with the algorithm, help us with the calculus, help us with figuring out when something that an insurance company does constitutes waiver versus something else they do does not constitute waiver.
I think what we have to do is we have to start by looking at what the purpose of the statute is. We've laid that on the brief. I'm sure that you're well familiar with that. But it's to prevent unnecessary litigation. And this court actually said to not vindicate continuing efforts to delay the case. It's to provide insurers with 60 days to correct violations, encourage fair claims handling, and to settle valid claims promptly and fairly. So we have to start with what the purpose of the statute is. And none of that was furthered by The response that was received to the CRN in this case, which was that we're denying the claim, not we need more information, not this wasn't clear. Then we have to look at the scope of the violation.
A simple denial, and this was a tad more perhaps than a simple denial, but a simple denial you would say is always a waiver. It just deny. We deny. You know, tomorrow, an insurance company responds to a CRN and says deny. Is that a waiver?
If we look at the plain language of the fourth and the second DCA's holdings, and by the way, I apologize, but I did file a supplemental authority, another DCA, second DCA opinion last night. I hate doing that. I apologize, but I found it and I filed it just so we had the full scope. But if we look at what they say, their statements are clear. When an insurance company responds to a CRN and denies it, the claim on the merits, it waives any allegations about defects in the CRN. That's what the cases say.
I just don't see that in the text.
Well,
Mr. Barrett, I mean, please, where is that coming from? I just don't understand.
It's coming from their conduct of responding to the merits. And we have to understand, again, we go to the intent of the statute. This is the bad faith statute. This is to hold insurance companies accountable.
I get all that. I fully get it. But the way we divine intent, and I know you know I'm going to say it before I say it. We divine intent from the words. And I just don't see that in the words of the text. Now, maybe they're there and I'm just not looking in the right place.
They are required to exercise good faith in trying to settle the claim within the 60 days. That's what they are required to do.
but how is their response? How do we know from their response that they're not doing that? If they're denying or they're not, maybe they are, maybe they aren't, but how is that? How do we gauge that by the response?
I look at this and I was trying to come up with something analogous beyond the med mal and sovereign immunity and all that stuff. But in the context of a property insurance case where the insurance company says there's late notice, they said there's late notice, the case law is pretty clear that if you go on to be able to adjust the claim and come up with a claims decision, it's probably going to be a question of fact on the prejudice question. So here, what we're talking about is an insurance company, and I wanted to get a little bit more into answering your initial question, Judge Jay, about, what is it here? In this case, they had already made a claims determination before the CRN was sent out. The CRN was sent out because they had already denied the claim. So they already had all the information, and the response to the demand the CRN was not, hey, we need more information to reconsider this claim. No, we're drawing a hard line in the sand. We're not paying this claim. There you go. Nothing else that you could do with respect to this CRN is going to change our mind. So what ends up happening is you get down the road 4 years. I don't know, but I would presume this case went all the way up to the Supreme Court, the underlying case, the breach of contract case. I assume that judgment's been paid. But what happens now, we're in a situation where, because they didn't say we have an issue with your CRN and it affects our ability to adjust this claim, the claim's been paid and now they get a second bite. They get a second attempt at avoiding a bad faith, which the statute doesn't allow.
Correct me if I'm wrong. What is being waived? What is actually being waived?
The right to receive a statutorily compliant demand, CRN.
Is it, or is it the right to seek a dismissal based upon the lack of a condition precedent?
Well, I guess tangentially, that is the effect of a non-compliant CRN.
The CRN is a condition precedent to bringing the case. It seems to me what you're waiving is your right to or what the insurer would be waiving is their right to seek dismissal.
Yes, that as well. But our argument was stemming from what the statute, what rights the statute provides.
Right, but where is to Judge McIver's question, where is the right to essentially helping the insured at that point? It's not their right, it's the insured's right. So it's kind of an odd situation. And I think to point to Frisco, the case that you just provided, I hope that you had a chance to take a look at it, but I think Judge Atkinson's concurrence speaks to essentially that issue, is that the legal sufficiency of the CRN is tested at the pleading stage, not at the time that it's sent. So there's a difference there And there's a rule that requires, at that point, the insurance company, if they're gonna stand on that, if they're gonna stand on the fact that you didn't satisfy that condition, then they have to deny that you did with specificity. And that's where Ingersoll comes in, right? Because Ingersoll is actually a pleadings case.
Right.
It's not a statutory waiver, grifting into the common law. That's not what Ingersoll's talking about. Ingersoll is essentially talking about what Judge Atkinson is talking about, which is the pleadings requirement. So is that not when it's really tested? Because that's when the insurance company waives their right? That they waive the right to challenge the condition if they don't deny it with specificity in the answer.
If we look at the fourth and the second DCA's cases, what they're talking about is you have responsibilities in the statute. The insurance company has responsibilities, and their rights are also established in the statute. And so when they take upon themselves to look at the CRN and to adjust the claim within the 60 days and make a claims decision, they are waiving the right to contest the sufficiency of the CRN.
Where does that come from?
That comes from the common law, the concept of waiver.
This is a statute in derogation of common law, is it not? This is not a common law right. Any of this that we're talking about with this insurance, with bad faith is not a common law cause of action, right? Okay, so
Not in this context.
Okay. So where does the common law waiver come in? It could come in, I think, to Judge Jay's point, if they undertake the obligation, right? If they say, here's the errors, maybe just hypothetically, you failed to meet 2, 5, and 7, I'm telling you what you did. And then maybe 5 years down the road, they come in and they say, oh no, you actually missed 1, even though you fixed 2, 5, and 7. Maybe there's something different there. Maybe there is, maybe there isn't. But just putting the obligation without the under the statute, where does that come from?
It's in the context of them providing the response and they all say if they make a response on the merits, and the statutes the cases don't say they have a duty to provide a response. They say when they provide a response on the merits and they don't raise an issue with the sufficiency of the CRN, that's when it is waived.
How do you determine the merits?
I don't see how it could be any clearer than it is in this case when they're saying it's not covered. We're not paying anything more.
Is that what they said in this case?
I mean, they say they reserve the right to raise additional information later.
It denies the allegations made by counsel for claimant, reserve our right to provide a more detailed response to the complainant, and reserves our right to assert additional coverage defenses, either known or unknown.
None of that has to do with the sufficiency of the CRN. That all has
Correct.
to do with the
So
merits.
is that the merits? Is that the merits of the, that's my question. You got it, Mr. Barr. That's my question. The merits of what? Because it's not defined anywhere. This comes from Evergreen, which I agree, spoke to a very narrow issue. And then it grew and grew and grew in the subsequent cases in the 4th DCA. And then it was adopted by the 2nd DCA in 2025, in another case, not the one you provided, but also in 2025. So, but that's my question. If we don't have a statute, we don't have common law waiver, who's determining the merits of what? The merits of the case that's going to occur in 10 years, the merits of the coverage decision, the merits of the sufficiency that the insured is required to provide, because that I think would be the relevant merits, but I don't know. And you're talking about the merits to the claim, denying the claim.
That is what 624.155 is the allegations of bad faith.
Mhm.
That is the merits. That is the merits. If they respond to the merits, which is the subject of the CRN, if they don't raise sufficiency of the CRN at that point, they're not saying here, we don't have enough information. They already denied the claim. They already denied the claim and said it's excluded.
So they're responding to the merits at an initial stage, and then bad faith comes into play ostensibly and often many years later, when the pleadings are amended after the whole case has gone through. Where, I guess my question is, where does the concept of waiver of inaction kick in? Is it having let the case go on for 4 years? You're making the argument, of course, that following the fourth and the second, that it should happen at the response to the CRN stage, and that if it's not spelled out in detail at the response to the CRN. But I'm wondering, how is that affected by the fact that bad faith isn't even alleged at the initial stage? It's appended later after years of finding out ostensibly how bad this insurer has been acting for the last 4 years.
Which I think weighs into the analysis here.
And sorry, I'm only throwing 4 years out as a broad example. I'm not talking about this case or suggesting that your insurer did something bad. I'm just.
But I think that really drives to the heart of the case, which is if they're allowed to lie in wait and see something that is, listen, the issues with the CRN are irrelevant to the claim. It had no bearing on the claim. We're talking about, did you cite the right policy number or the right policy provision, and did you say the name of the person? That's literally what we're talking about. But
I guess kind of what I'm asking is, how are you even supposed to put things in your CRN related to something that's not going to even be appended into the claim for years to come?
how are we?
How are they?
How are they supposed to put something in their response?
I'm sorry. Sometimes I flip parties. How is the insured supposed to put into their civil remedy notice allegations that aren't even going to be alleged for years?
But in this case, if we talk about this case, none of it matters because they already decided which provisions of the policy applied and who.
Well, does it not matter though to that question of waiver by inaction?
What they are asking you to do is to say, we don't have to say, even if we identify or don't, we don't have to say anything about the sufficiency of the demand letter. We get to a final judgment, we pay the final judgment, the complaint's amended, we add bad faith. Then we can say it's insufficient. They have to send another one. And at that point, we've already satisfied it because we paid the judgment. And that's not what is intended by 624.155. I see I have 3 minutes left. I'm sure I'll have more questions. I'd like to reserve that time. Thank you.
Certainly. Thank you.
Your honors, may it please the court. My name is Drew Peeler and I represent the Appalachia Florida Farm Bureau in this matter. And I'd like to start by just going ahead and narrowing down why the text of the statute itself is so important. So when we look at the idea of common law waiver, we've discussed in the brief, and Your Honor, Judge McIver talked a little bit about the first two requirements, the existence of the right, the question about whether it's the defense that you would raise in the pleading stage of failure to satisfy conditions precedent, or whether it's the right to notice. We don't even have to get into which one of those it is. Obviously, we contended in the brief and still contend that it's the litigation right that they failed to satisfy condition precedent. But even going with his assertion that it's this right to notice that is waived, the reason this is so important is because there's clearly no express waiver here, and they've never argued that it is. So it has to be this quote unquote conduct that implies an intentional and voluntary waiver, as this court discussed in Smith v. Carlton. And I think the quotation from the reply brief that opposing counsel used is very instructive of the fatal flaw in his argument on this matter. And the Richards v. Dodge, it says, and this is the part they quoted, the acts or conduct need not be positive, but can consist of a failure to act, or more particularly, a failure to speak when under some duty to speak. And that's why the text of the statute is so important, because that's where we figure out whether or not the insurer has an actual obligation or duty to speak in this scenario. And this is, we talked
Didn't
about—
you hurt your argument, counsel, by not making the response definitive by the reservation language? It seems to me an easier question if your client had just said, no, nothing to see here, deny. But the reservation language almost wanders into what Judge Kilbane was talking about earlier, almost wanders into, but we're reserving everything else that might be out there. Why is that not the case? That gives me a little bit of pause. I'll be candid with you.
Well, Your Honor, just because someone has the ability to raise these things, and certainly, if the answer was different, obviously the answer to the question would be more obvious, but I don't think it really changes anything here.
You would
because-
agree it would be an easier question if it was a one-word denied, or we deny it?
Not necessarily, Your Honor, because I don't think that there's any support for the idea that this reservation of rights, which expresses that there clearly wasn't an express intent voluntarily to relinquish.
In your opinion, is Evergreen Lakes wrongly decided, or was Evergreen Lakes correctly decided and the cases subsequent to Evergreen Lakes have just continued to draw the line further and further back incorrectly?
So, Your Honor, I think the result of Evergreen Lakes and probably Bay immediately thereafter were possibly the right result, although not necessarily for the right reasons, relying on the statute as the reason rather than this.
Does the right to common law waiver exist in this context? Can your client waive?
Well, Your Honor, I think that there's an argument that that's not entirely true. So going back to the Ingersoll case, the first half of their certified question had to do with whether section 758.59 was subject matter.
My question. Does your client have a common law right to waive and ostensibly also waive by inaction their rights in these proceedings?
I would say that they most likely do, Your Honor. They have an ability to waive. They could certainly reply by saying.
Let's just say, for the sake of argument, because it makes my small brain easier to understand it, that what they are waiving is their right to seek dismissal based upon a faulty CRN. Where would the appropriate lines be to draw? Where did this line of cases go wrong, in your opinion?
So, Your Honor, I believe they went wrong in forgive me, I think Neal was the third decision when, just like the Ingersoll case, they were dealing with essentially a pleadings issue. And they went and decided that it was waived. So the appellant in that case argued that it was waived because they never brought it up at any point during the litigation portion. And the court, I think, in line with Ingersoll, correctly ruled that it would have been waived, but they extended their holding and their ruling unnecessarily to this idea that you waive it by not doing so within the 60-day period or in an initial response to a CRN. And so I think.
So I'm going down a little bit of a hypothetical road, so I understand not the case before us entirely. But let's say the argument wasn't that your client waived by not asserting it in the response. Did they waive it by not seeking dismissal of the case early on before the appended pleading stage when bad faith comes into play 4 years later? Or do they get a second bite at the apple? Do they get to 4 or 10 or decades later when someone decides to append in bad faith? Do they get to then look back all those years and say, well, we didn't get it dismissed before, but now since they're appending the pleading, we get another bite at the apple. We didn't waive anything.
I think in that case, the issue would turn on something other than waiver. I think a court, if I understand your hypothetical correctly, I think you're saying same bad faith litigation, they amend the complaint at some point of the bad faith, not the original litigation, several years into it, and then you waive it or you raise the defense for the first time at that stage.
I guess my confusion is your bad faith claim. You're appending this on after the whole case has run out on liability and you've lost that case. And now they're going to seek bad faith and they have to append that back onto the original case. But you're still looking back to the original CRN, which was 4 years ago.
Your Honor, the difference, I think, is that the CRN is not a statutory prerequisite to the underlying action as it is in this. And because, as one of your honors touched on, this is in derogation of common law, it has to be strictly construed. And, you know, the reason I was going back to the Ingersoll case originally is that's actually the exact formula that the fourth DCA should have followed after they figured out that the defense wasn't raised in the initial pleadings. They didn't automatically jump to waiver as the fourth DCA did. They went and looked, you know, oh, do they have a duty to have done so at some point already? And they correctly found Florida Rule of Civil Procedure 1.120, which says that you have to specifically raise a failure to satisfy a condition precedent in an answer to a pleading. And going back to, again, why we're looking at the text of the statute. And, you know, I already mentioned the elements of waiver and why we're looking at conduct, but I think it's the second or third sentence in the initial brief under 1A. So basically, the way that it's framed is said the trial, and I'm paraphrasing here because I don't have it in front of me, but essentially the trial court erred by allowing Florida Farm Bureau to assert a defense outside of the 60-day statutory window to do so. And that's the reason that's so important is because under these elements of waiver, where we're talking about negative conduct and a failure to where it's completely absent, then whether or not there's a duty to raise this is the essential question. And this isn't something that's entirely new or unique to this. Let's take, for example, I know framing the right the way that opposing counsel does is this right to receive notice. Okay, well, we have the proposal for settlement statute and rule, which are also in derogation of common law. And a proposal for settlement is sent in the middle of the case, and you may have the right to raise that it violates the rule and is insufficient and unenforceable at the time you receive it. You may know it. You have certainly have the ability to say something, but you don't waive that right by not doing so at that stage. You don't have to raise that until after a judgment is entered and they seek to enforce the proposal for settlement, because the rule and the statute don't say otherwise.
Well, and I don't disagree with you, counsel. I don't see anything in the text of 624-155 that talks about a duty to raise. But I agree with you. But you would agree that you could assume a duty that doesn't exist by wading into something that is not required.
Your Honor, without getting into the weeds, I would say there are certainly some possible scenarios, but that's
What about
really
what I said?
Judge
Right.
Kilbane's example where you
Tell them what they did, but leave one out.
you leave one out. And there
they
are
fix it.
deficiencies with 2, 3, and 4. And it turns out the bad one's 1, but they don't mention 1. So they've assumed a duty they don't have, and they don't properly
it poorly.
discharge that duty. And so by virtue of not discharging that duty, would that not be a waiver?
I would
Number
say-
1.
Your Honor, I would say in that instance, it probably would be because, I mean, in that very limited hypothetical, you were speaking directly to you have decided to address the deficiencies. So
Right.
when you decide to address the deficiencies, there's an understanding by that conduct that you were raising all of the deficiencies unless you say otherwise. It's sort of going back to when you asked whether Evergreen was correctly decided and how these procedural service issues are fundamentally different. The mere act of responding at all when is fundamentally inconsistent and an acknowledgement of actual receipt. So if you don't then raise that, hey, you didn't get this to me properly, that's a situation that pretty uniformly across the law, they treat as a waiver, or I don't, again, want to get into the weeds, more estoppel, because the response without claiming that is inconsistent with a later position that essentially says, well, we never received proper notice, even though you did. And kind of the same thing in Bay, where it was the wrong entity, but the right entity responded. Those are all, you know, I think in the reply brief, opposing counsel characterizes them as distinctions without a difference, but that's kind of fundamentally not accurate, because those mere acts of the correct party responding without raising that the correct party wasn't put on proper procedural notice, is an acknowledgement that you did in fact receive the substantive portion of the notice.
So the basic premise of every appeal, right? The court below erred. Let's say we do not decide to join our sister courts. Would you concede that the case law on the books is still on point?
The fourth and the second DCAs to this case, yes, Your Honor, at least the,
And that there is no existing conflict?
correct.
So the answer to the question of the court below erred by what it was bound to is definitively yes. Do we have to reverse anyways, even if we choose not to join our sister courts? We could say we don't join them, but that was the binding law in front of this judge, and this judge totally ignored what that binding law said.
No, Your Honor, because this court's free to address the issue as it sees fit, and had the court made that decision,
We are, but the judge below wasn't.
Yeah, what
He
do you do
skipped a
with,
step.
what do you do with PARTA? I mean, the Supreme Court of Florida. The judge was duty bound to follow those cases. So, and the judge did. It,
Even if we agree with him,
correct.
well, assume we agree but we're in a different seat than he was in when he decided it.
I realize, do you have to lose is not a good question to get during an argument, but how do we deal with this?
Your Honor, I do not believe that you have to send this back to the lower court. And fundamentally, what would happen if you did would be, I guess you would send it back saying they erred and were bound. They would enter this order. We would appeal. We'd be sitting here doing the same thing, except Mr. Barr and I would be sitting on opposite tables, and this court would still be reviewing de novo because it's a motion to dismiss. And so there is no abuse of discretion standard that gives some sort of weight to which side the lower court.
But we would in that case not at least be endorsing trial courts ignoring vertical stare decisis.
That's true, Your Honor, although certainly if you were to.
Even though the waltz of it does seem a little ridiculous.
Your Honor, yes, and in an opinion, should you agree with our position, obviously this court is free to spell out how it does not endorse that situation at all, but given that this is a de novo review, given that there's no requirement that I'm aware of or that opposing counsel has pointed out in the briefing that requires this court to send it back for that specific reason, then you would still end up addressing it on the merits. And should you agree with our position, affirming the decision of the trial court based on, I guess, essentially the tipsy coachman doctrine, and essentially, and I would be remiss if I didn't point it out because it was a feature in the early part of the reply brief about how there's a lot of issues that we've raised that weren't expressly raised below. And there's case law directly on point on this issue from the Florida Supreme Court. It's
Well, are we able to utilize tipsy coachman? I'm just thinking this through with you, where the trial court categorically violated PARTA. I think that's pretty clear. There were DCA cases the court was bound by, according to PARTA. And we may disagree with those DCA cases, but the Supreme Court of Florida has told us any DCA matters to the trial court. How could we affirm on a tipsy coachman when the Supreme Court has told us that judge was duty bound to follow those cases?
Well, Your Honor, again, they may have been duty bound to follow those cases, but now that we are here, there's nothing that I'm aware of, or again, that opposing counsel has raised, that this court is now duty bound to reverse for this reason, even if it otherwise would agree and send it back and then have us come back here at different tables.
But what if we do agree, but so then we reverse to do what? To say, do it again, even though it's an interesting intellectual exercise, because it seems, had there been an initial paragraph about the cases and that he disagrees and then indicate why, but then found for your friend on the other side, it seems like then that procedural posture is different. So is that something that we're gonna have to address? And if so, how do we do that? I think is the,
Your Honor, I think the proper way to address it would be to, as I said, just include in an opinion affirming that, this is not an accepted practice the trial court is bound to follow. However, we're not bound to remand here on de novo review. We can address the issue as is, and we have decided this. And really to kind of go back to like the merits of the issues in this case, something stood out to me because something this court has reiterated on numerous occasions is the supremacy of the text principle. And during opposing counsel's argument, he began his analysis with the purpose of the text rather than the language of the text. And again, we look at the language, and as everybody's acknowledged, there's nothing in here creating a specific duty of any kind on the insurer, certainly not a 60-day window to raise these defenses. And another situation where this has been addressed was a Thompson v. Geico case in the 4th DCA, where it was a PIP statute that's fundamentally similar, pre-suit notice requirement, nothing requiring the responding party to raise deficiencies. And in that case, the claimant actually asked if they could let them know if there was anything wrong with their demand letter in accordance with the statute. Geico responded on the merits and did not say anything about deficiencies, raised them once the litigation had started. The trial court granted them summary judgment. The appellate court affirmed, and one of the arguments was, hey, they never said anything at the response to pre-suit notice stage when they responded on the merits by saying it was denied and et cetera. And the 4th DCA, interesting in that case, because it was 2022, so in the middle of all of this string of CRN cases they had, said, well, we don't see anything in the statute requiring Geico to let them know of deficiencies in a response, whether they ask for it or not. So, we still affirm. Now, as opposing counsel pointed out, this court has certified conflict with this case. Judges Kilbane and McIver, you were on. It was the Mercury case in this court, I believe, 2023. But it did not certify conflict with the support that, or the reason that we are relying on that case. It certified conflict based off the fact that the 4th DCA didn't utilize the supremacy of the text principle in figuring out what the statute actually requires, and they disagreed that the pre-suit notice was deficient actually to begin with. And based off of, again, using the supremacy of the text principle and applying it to this statute, there's clearly no duty or obligation. The law on waiver when it comes to negative conduct requires that there be some sort of duty or obligation to speak and then failing to do so. Because all of that is absent, it's because it's so similar to some of these other situations like PIP, PFS. We ask this court to affirm the decision of the lower court. Thank you.
Thank you. Rebuttal?
Importantly, Pelley concedes that they can waive the requirement for a pre-suit notice. The distinction he tried to draw was, and I know there was some discussion earlier about this, but the notice response indicates there's some deficiency, but not all, versus a decision on the merits being the substance of the CRN.
What's your best argument, Mr. Barr, that the response in this case, reserving until later, is a waiver? What's your best argument there? That the verbiage used here, as opposed to saying denied, the reservation language would reach the level of being a waiver. What on behalf of your client, what's your best argument?
Best argument goes directly to the 6 cases that we cited, that they were able, regardless of whether they had a duty or not, they're saying they don't have a duty. They undertook the duty to tell us that they were deciding this case on the merits. They had everything that they needed to make the decision, and they needed nothing else. And there's no issue that we document with the CRN. So because they chose to decide, make a claims decision based on the information that was provided.
I'm talking about the verbiage. I'm talking about the verbiage of their response. That I don't read the statute as requiring that duty. I just don't. But what is your best argument that they assume that duty here in this case?
Because they did it. I mean, I guess I don't understand the question because it seems to
I'm
me-
talking about what they said. And so you would say that that verbiage in this case at that time assumed a duty they didn't have. I know you say the duty's there, but assuming it's not there, you're saying they assumed the duty here by virtue of what?
They assumed a duty by virtue of what is the question?
Yes.
It seems so clear to me, and maybe I'm missing what you're actually asking, because if they're standing here saying we have no duty, and by the way, the Imhoff case, the Supreme Court case, Imhoff, we recited that in our library, makes it very clear that they should respond. They say it flouts the purpose and intent of 624.155 to not, and is also evidence of bad faith. What we're saying is that if they don't have a duty and they undertook the duty and they made a claims decision, and that's what Evergreen and on down have said, if you make a claims decision and you don't raise any deficiency in the CRN, because what you're saying is we have everything we need. We don't need anything else. And in this case, even
Where are they saying that? Where are they saying that? And where are they required to say that? Because we've got a claims handling process, and then we've got a CRN process. We've got a bad faith process here.
they've already denied the claim.
Okay.
They've already denied the claim and they're not changing their position. They
Okay.
denied the claim 3 months before we filed the CRN.
Okay. So because they didn't change their mind when you got the CRN, you're reading into all the things that you're saying were not in the portal response, correct? All the things that you were just talking about, they've made the decision, they've done all of these things, none of that, and they have all the information they need. None of that was in their response, in the portal response to the CRN, is that
It's in
correct?
none, it's in none of the responses in any of the cases.
Okay, well, because they're in the cases, they're talking about the response to the CRN. That's what I think Judge Jay is asking about, the actual response in this case. I understand what you believe the purpose is, and we can look at the purpose if it's in the statute. I don't believe the text.
I don't agree with that. Because
okay.
the concept of waiver, you have to base on the totality of the circumstances. And the totality of the circumstances involves looking at what the purpose of the statute is, the severity of the violation, and the response in this case, which they didn't have to send, they
Where does
did.
that come from? Where is that derived from, that waiver?
We cited that in our brief. I know we cited that in our brief. The concept of waiver is based on the totality of the circumstances. It's not just based on one word that you say or don't say. In this case, they already denied the claim. We sent a CRN. They responded, didn't identify any deficiencies, and said, we're not changing our position. So under the 6 cases that we've cited and relied on, and the Pardo question, am I over? I'm over. Okay. We asked the court to reverse. Thank you.
Thank you, Mr. Parr. Thank you both. It was well presented. We are officially in recess. Thank you.
All rise.